Oh, okay. There was an amendment to the indictment. Change to run. One of them said,
Do you want me to email? I'm just going on council too.
thank you. Good morning, sir. Are you Floyd Torrin?
Yes, ma'am. Good morning.
And Mr. Radford, will your client waive the formal reading of the indictment in each case?
Yes, ma'am. He will.
Mr. Torrin, in clause number 25 DCCR 0794, you're charged with a third-degree felony offense of attempt to commit theft or property from an ATM, and that's from May 10th of 2025. The indictment alleges in count 2 that you were convicted of the felony of possession of a controlled substance, a second-degree felony, August 16th of 1999. How do you plead to that charge?
Guilty.
And is that prior conviction true? Did you enter your pleas of guilty and freely and voluntarily?
Yes.
And did you plead guilty because you actually did what they've charged you with? All right, give me just a second and I'll get that out of there. The efficiency of going. All right, then, Mr. Torrin, in cause number 25 DCCR 1152, you're charged with a third-degree felony offense of evading arrest or detention with the use of a vehicle from June 20th of 2025. The indictment alleges the same prior conviction of possession of a controlled substance in count 2. And how do you plead to that charge?
Yes.
And again, is that prior conviction true? Did you enter your plea of guilty and true, in this case, freely and voluntarily, and because you did what they've charged you with? Each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Radford? Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached in each of these cases is that, the agreement was that the state allowed you to plead only on counts 1 and 2. And that your punishment is the full range of punishment, which is a second-degree felony, between 2 years and up to 20 years up to the court. Knowing that had you gone on the full indictment, you would be looking at a habitual status, which is 25 to life. Is that your understanding of your agreement?
Yes.
I want to make sure you understand you have every right to have a jury come in and determine 2 things. 1, if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that right and you're leaving it up to me, and also waiving your right to appeal as long as I stay within that 2 to 20 range. Do you understand? And is that what you want to do?
Yes, ma'am.
Do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objections.
It's admitted in each case. Is there any evidence that Mr. Torrin is not competent?
No, ma'am.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Also find that you entered those pleas of true to counts 2 freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to reset your cases so that the probation department can do a pre-sentence report. That'll give me more information about you, your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and get that information to Mr. Radford, and he'll get it to me so that I can review, and he'll present more whatever that day when we come back for sentencing. All right?
Judge, I'm going to have some documents I will present.
Thank you.
I'll email them to the clerk and CC Mr. Smith.
Okay. Make sure you get them to probation, and they'll attach them with the PSI as well.
Yes, ma'am.
All right. Thank you. You can go back with the bailiff.
May I be excused?
Yes, sir. All right. Yes, sir. All right. Are you Elaine St. Clair?
Yes, ma'am.
And Mr. St. Clair, you were previously in court in cause numbers 23 DCCR 2044 and 23 DCCR 2117. Entered pleas of guilty in each of those cases. I've received the pre-sentence report. Has everyone received that report?
The defense has, Your Honor.
State has, Your Honor.
Are there any additions or corrections?
I think we need to correct some stuff, Your Honor, if we can swear him in and let me ask him some questions.
Raise your right hand the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Okay, go ahead.
Mr. St. Clair, in your PSI, you stated that when you were doing your interview, you stated that you were in the wrong place at the wrong time. Is that correct?
Yes, sir.
And you understand that being there and participating in this is the same thing as committing the crime, correct?
Yes, sir.
Okay. So you did commit the crime.
Yes, sir.
Okay. And you also said somebody said you did something you didn't. You're talking about you weren't the one planning this, organizing this,
Yes.
but you were involved in it.
Yes, sir. I was involved.
Okay. And as far as the thing about just taking probation just to be out of jail, is that you took probation because you don't want to go to prison, correct?
Yes, sir. I don't want to go to prison.
Okay. All right. And you understand that's the options are go to prison, take probation, or go to trial, correct?
Yes, sir.
Okay. And you thought taking probation was the best option.
Yes, sir.
Okay. And you are guilty of this, and you did do this.
Yes, I did.
At least you participated in this, correct?
Yes, sir.
Okay. All right. Pass the witness, Your Honor.
Anything?
No, Your Honor.
Okay.
So, Mr. St. Clair, obviously we've had numerous conversations here about kind of a few things. One, the opportunity that you're being given
Yes, ma'am.
with these probations, and also with what's going to happen and the jail disciplinary and following the rules and things like that.
Yes, ma'am.
One thing I can say, and I'm pleasantly surprised, is that you haven't had a jail incident report since we had our last really serious conversation about that.
Yes, ma'am.
And so I appreciate and hope that maybe you have grown up some and will continue to do that so that you can be successful and live a whole different life than what you've been doing.
Yes, ma'am.
So I'll go over some conditions and some more instructions in a minute. But first, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily.
Yes, ma'am.
Find sufficient evidence to find you guilty. However, in cause number 23, DCCR 2044, I'm going to follow the agreement and defer all proceedings, place you on probation for 10 years.
Yes, ma'am.
You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. And I'm going to go over some specific things that are going to apply in both of your cases in just a minute. And cause number 23, DCCR 2117, also find sufficient evidence to find you guilty, but I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years.
Yes, ma'am.
You're ordered to pay the $1,000 fine in that case and to follow all of the rules and conditions of probation. One of those conditions is going to be in each case that you enter and successfully complete the cognitive track of the ISF program. And that's just a program that is intended to help you to make better decisions, to not be around the wrong people, to not be part of the lifestyle that you've been living. Otherwise, you're going to end up in prison for a long time. You'll be on the high medium caseload in each of those cases until probation finds otherwise. After you've been on probation for a while, that means you'll have to report more. They're going to keep a better eye on you. You're going to have to get your GED if you haven't graduated from high school. You're going to have to get a job and do all of those things. And they're there to help you do that. Okay, so if you're feeling like you can't do something, or you're struggling, or you don't have support at home, probation's there to help you. They're not trying to trip you up. Nobody wants you to spend potentially the rest of your life in prison, but that is going to be 100% up to you at this point. You're going to have to ask for the help and make that change and grow up and be more mature at a younger age. Do you understand?
Yes, ma'am.
The last thing is that a condition of your probation is that you do not get any incident reports in our jail or in ISF.
Yes, ma'am.
That will be a violation of your probation, and you're going to, if you do that, you'll be back in court before you ever get out and see the light of day again. And you could be looking in each of these cases at a minimum punishment of 5 years up to the rest of your life in prison.
Yes, ma'am.
And based on the nature of these offenses, it's not going to be y'all coming in here and arguing for some 2, 3, 5, or 5, 6, 7 year sentence. I'm sure Miss Malvina is going to come in here and ask for something huge. It depends on what happens. I can't prejudge it, but I'm telling you right now, you better not
Yes, ma'am.
get in trouble, because that's the one thing that you've been doing that's been extremely frustrating to me. So you've learned how to do it. Whatever you're doing, you're staying away from the riffraff out there, and I appreciate that. Continue that. Do what you're supposed to, and and you'll be able to change your life and be hopefully a success story.
Yes, ma'am.
You understand?
Yes, ma'am. Thank you.
A condition of your probation.
Alexis Baja Cooper and her co-defendants were involved in an organized retail theft ring totaling tens of thousands of dollars. The court emphasized the severity of repeated offenses and the role of prior criminal history in determining sentencing. Plea agreements were carefully reviewed to ensure defendants fully understood the consequences, including probation conditions and firearm restrictions.
Also, excuse me, in each of your cases, you are not allowed to possess a firearm at all. That means obviously you personally possess one. You can't be in a car with someone else that has one. You can't be in a house with someone else that has one. If somebody has one, you're out of there. Do you understand?
Yes, ma'am.
Okay. I'm handing you the trial court certification in each of your cases that shows that these were agreements that I followed, and so you waived your right to appeal. Again, keep doing what you're doing. I really hope that you have, I'm impressed that I haven't gotten another incident report, and so I want to acknowledge that and tell you that I know that takes a lot out there, and I appreciate it. Continue that.
Thank you, ma'am.
Yes, ma'am.
If I may, would the court consider continuing the admonishment that you've given us previously about no contact with Gerard Crane or any of the other participants? I do not know who they are. He knows who they are. He knows who he was hanging around with
Sure.
from his high school class.
So
Just so that he's
obviously
not
you're
around
not
that
to you're not going to hang around Jared Crane because we know him, but there were others that were involved. You need to, and you're going to learn at ISF that when you come back out of ISF and you're on probation, that you've got to put yourself in different situations around different people. Get a job, go to school, whatever it is, go do that, go home. You know, the hanging out, if you're caught doing that with people that are also in trouble, then you're just going to be right back in there with the violation. Okay? All right, you go back with the bailiff.
Thank you, Judge. We of course, you know, it's just that.
Good morning. Are you Alexis Bourgeois Cooper?
Yes.
And Ms. Bourgeois Cooper was previously in court, entered a plea of guilty to the state jail felony offense of theft of property. The agreement was for a cap of 12 months in the state jail prison. I received that pre-sentence report. If you both had an opportunity to review the report.
Defense has your,
State has to.
Any additions or corrections?
none from defense.
Not from the state, Your Honor.
All right then.
Your Honor, I do have one brief witness, if the court will allow me.
Sure. Go ahead. You can call your
The
witness.
state calls Jennifer Shearer.
Jennifer Shearer. And Ms. Bourgeois Cooper, if you'll just kind of step just to the corner right there, closer. There you go. Ms. Shearer, you can come on up. Good morning, ma'am. Morning. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you, ma'am. You may proceed.
Would you please state your full name for the court reporter?
Jennifer Marie Shear.
And Ms. Shearer, how are you employed?
I work at HEB and I'm with the Loss Prevention Department.
How long have you been with the Loss Prevention Department?
5 years.
And through your employment as a loss prevention officer with HEB, have you become familiar with the defendant Alexis Bourgeois Cooper?
Yes.
Please explain briefly to the court how you have come to be familiar with her.
She originally came on our radar back in February of 24 when she started stealing from our stores in Montgomery County. And then she was pulled over shortly after stealing at a Conroe store. And that's how we were able to ID her.
And you understand that she's already pled guilty today to a state jail felony level theft for $3,547 worth of cosmetics and makeup from the HEB store in Port Arthur. You understand that, correct?
That's correct.
And she committed that offense along with co-defendants Katira Green and Monique Wynn. Please briefly tell the court your familiarization with Katira Green and Monique Wynn.
Both of those parties are part of an organized retail crime and a spree group that we've been following about at the same time. And they have in Houston area, Katarina Green has for stealing from our stores about $56,000 worth of cosmetics, and then Monique.
Your Honor, I just object to any co-defendants' restitution amounts or what they've pled guilty to or found guilty of.
That's overruled. Go ahead.
And then Monique Wynn was about $42,000. And they're part of a ring that was hitting our area for a short period of time.
During the period of February the 24th through April the 24th, how many actual thefts did your investigation link to the defendant, Ms. Cooper?
10 events.
for a total loss of how much?
$8,956.50.
Now, for the entire ring, what approximate dollar amount would you put on? Well, let's break it down. What about for Wynn, defendant Wynn? How much would you attribute to her?
About $42,800.
And for the defendant Green, how much would you attribute to her?
$56,000.
Is it fair to say, in your opinion, that this group has been operating as an organized retail theft ring?
Yes.
And have you, in your 5 years of experience in loss prevention, how would you rank this endeavor?
This is about the second highest ring we've had in ATV.
And you prepared a report?
Yes.
Okay, and you reviewed that report
That is
prior to testifying here today?
Yes.
All right, I'll pass it to Mr.
Thank
No
you.
questions, Your Honor.
Thank you, ma'am. You can have a seat.
Judge, just if I may, I don't know what I was thinking today that I agreed to a cap of 12 months. Certainly see how the court would be inclined to give this defendant more than 12 months, Judge. Well, actually, I do know what I was thinking. If you look at her criminal history, she actually has not been to prison before. She's got a number of misdemeanor thefts, at least theft arrests.
Not enough felonies that have actually been convicted and followed through that would get enhanced either. So, I mean, I could see my initial thought was the same. I wasn't quite sure where this came from. But I can see that it's not really enhanceable at this point based on any other felonies. So, Mr. Lane?
Well, Your Honor, obviously, we're asking the court to follow the agreement that we entered. The court does have the ability to sentence her to 12 months in the state jail. She did have a 1244 in Harris County that she did 10 months in the county jail. She does have a pending case out of Hidalgo County. What had happened back in 2019 and 2021 is her father and her grandmother died. And then she did get involved with these thefts. That was a major setback for her. She does have custody of 3 children. She is a phlebotomist and has some other skills that she can earn money with. So we're asking that you follow it. She has a family law hearing that's the 24th of this month. We would ask you to sentence her to 10 months in the state jail.
Mr.
Oh,
Holmes?
we'd ask for the entire 12 months, Judge. Excuse me. I think she's benefiting from Mr. Lane.
Is that who is it? What is she?
She's benefiting from Mr. Lane's negotiation with me in working me down to a cap of 12. I'd ask for the entire 12 months.
Ms. Bourgeois Cooper, one of the things that stood out to me in your pre-sentence report, well, a couple of things. One, your criminal history is ridiculous. It's when I start having to turn page after page after page, that's a problem. And your version of this about I didn't really know what was going on, and I just went with somebody at the store, and I didn't know what county I was in. You didn't know what county you were in because y'all were going from county to county to county, and still you're not going to help yourself by saying anything right now, okay? Because Ms. Shear was just here and has you on video at other stores doing the same thing. So I don't dispute what she said under oath at all. I think Mr. Lane did an amazing job for you, and you are very lucky because he got you the cap of 12 months because you deserve a lot more, in my opinion. At this time, I'm going to find that you entered your plea of guilty freely and voluntarily. And in cause number 24 DCCR 1296, find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of theft of property. Sentence you to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lane. And all I can tell you, Ms. Bourgeois Cooper, is that I hope you learn your lesson.
The judges balanced mitigating factors with the seriousness of the offenses. Probation, fines, and state jail time were imposed, along with strict conditions to prevent future violations. Courtroom proceedings make it clear: accountability, prior record, and compliance with the law determine the outcome, not leniency or negotiation.